I'm most grateful for your assistance in clearing the chamber. Can I say at the outset that I would like to place on record that the overwhelming majority of staff who work in Birmingham's housing department are dedicated and provide a caring service for their customers. But the case I'm raising tonight does raise serious questions about certain individuals, and I shall explain. My constituent is called Nicola Shipley. She's a young lady who's seeking to carve out a career for herself by working in a very demanding job. She lives alone, having bought a house in Jakeman Road, Balsall Heath. The road in question consists of terraced houses. Most of the properties are either owner-occupied, some are owned by housing associations. She bought her house in 2006. Nicola Shipley lived happily in the house in Jakeman Road for 5 years until October 2010. The property next door to her was owned by Mosey District Housing Association, and she had excellent relations with the tenants, as she did with her other neighbours in the multi-ethnic community living in Jakeman Road. In 2010, a new tenant moved into the house next to her. The tenant had formerly been a council tenant who had effected a mutual exchange from his former property in Bilsey. Now, Mr. Speaker, mutual exchanges within social housing are commonplace, as the Minister well knows. And what happens is that tenants wishing to exchange will need the approval of their respective landlords. On the form that's used by Birmingham City Council, the tenant is required to provide certain information, and there's a section headed for office use only, where a housing officer carries out a check of the tenant's housing file to ascertain whether there are, for example, rent arrears or breach of any tenancy conditions, such as antisocial behaviour. The form is then signed by a housing manager and the tenant advised of this decision. Since the new tenant moved into the property next to Nicola Shipley in October 2010, her whole life has been turned upside down. I quote from a letter that she sent to me in December 2011, when, in desperation, she made contact with me, having tried for a year to get her concerns addressed by the Housing Association and by Birmingham City Council's Housing Department, who were the former landlords of the new tenant. She says, "I am a homeowner and have previously lived peaceably and quietly in this respectful family, community and neighbourhood for 5 years. Since 2010, in October, I have felt unsafe, vulnerable, harassed, intimidated and threatened in my own home. The constant extreme noise from the playing of loud dance band music and intimidatory and antisocial behaviour has severely affected my quality of life and those of my neighbours." What is scandalous, Mr. Speaker, is that this pattern of behaviour was known to his previous landlords, Birmingham City Council, but the officers in the Housing Department who approved the transfer deliberately and willfully conspired to ignore the Council's own mutual transfer procedures and did not tell the Housing Association about his past appalling record. These officers knew that the Housing Association would not have allowed the transfer to proceed had they known, and the Housing Association have made that clear to me on many occasions. In essence, Mr. Speaker, certain officers in Birmingham's Housing Department dumped this problem on the Housing Association by omitting to tell them the true facts, while wrecking the life of a young woman in the process. As I have said, since October 2010, Nicola Shipley has had to put up with constant noise playing throughout the night until 4 or 5 in the morning. The police have been involved, individuals have been arrested at the property during these continuous all-night parties, and the tenant has had his children taken into the care of the council. The RSPCA has been involved over the dogs kept at the property. There have been numerous complaints about the condition of the front and back gardens of his property, but neighbours are fearful of the consequences if they collectively complain or offer themselves as witnesses in a court. Furthermore, on the 13th of July 2011, this individual was sentenced to an 18-month community order and a £100 cost for having an offensive weapon and neglecting his 2 children. My constituent is, therefore, left in a situation where she's scared and fearful of living in her own house, but she cannot put it on the market for sale or rent it out because she would be obliged to divulge the behaviour of her next-door neighbour to any prospective buyer or person who wishes to rent her property. Otherwise, she could be sued. Mr. Speaker, these problems, as I've said, weren't caused by this young lady and her neighbour. They were caused because certain officers in the council's housing department, including the housing manager who signed the transfer form, conspired to get rid of their problem by deliberately withholding information about the tenant's past behaviour, which resulted in the council taking him to court back in August 2009. On the 17th of August 2009, it was reported in the Birmingham Mail under very bold headlines, "Loud music made Birmingham's neighbours' life of hell," that a Birmingham dance fan made his neighbour's life a misery for 7 months by playing loud music into the early hours of the morning. The newspaper report says that the noise coming from Mr. Sinclair's flat, and his name is mentioned, made the victim's kitchen vibrate, and although at one point he found his equipment had been confiscated, it did not stop him. Mr. Sinclair, 25, admitted 2 charges of failing to comply with an abatement notice, and he was fined £115 plus costs. And the magistrate's chairman, Dr. Burton, told him, "You caused your neighbour so much stress, anguish and worry." Now, Mr. Speaker, the article in the Birmingham Mail details the fact that the first complaint about the behaviour of Mr. Sinclair was made by his former neighbour in November 2008, and the City Council obtained an abatement order on the 9th of January 2009. This had no effect whatsoever on Mr. Sinclair's playing of extremely loud dance band music, and a warrant was eventually obtained by the City Council to remove the recording equipment, including a CD player and TV speakers. Again, this had no effect on Mr. Sinclair's behaviour, because further complaints were made by his neighbour, and after the council had investigated them, another warrant was issued. Mr. Sinclair's newly purchased sound equipment was again taken away. Now, all of this, Mr. Speaker, is surely clear evidence of this tenant's breach of his tenancy agreement with the council and his antisocial behaviour towards his neighbours, which went way beyond an occasional occurrence, but was part of a lifestyle whereby he had no regard whatsoever for anybody else. These serious breaches of his tenancy ought to have resulted in Birmingham's housing department pursuing a course of legal action to have him evicted from his property, but instead of which they allowed a mutual exchange to take place and kept quiet about his background. When Nicola Shipley first wrote to me, I pursued the matter with the Mosey District Housing Association and the City Council. I wrote to the Director of Housing, Elaine Elkinson, asking for an explanation as to why the mutual exchange was sanctioned and why the Housing Association were deliberately not told about Mr. Sinclair's past case history, which was in the public domain. Elaine Elkinson passed the matter to a Sheila Espin, Head of Landlord Services, who then involved a Tracy Radford, Head of Integrated Services for Landlord Services, and so began a game of pass the case. This went on until eventually I received a letter from Sheila Espin dated 21st of February 2012, in which she offered apologies on, I quote, how this case was managed, and saying that she'd written to Mosey District Housing Association and Nicola Shipley apologising for the distress that this had caused. There was, however, no explanation as to why the mutual exchange had been agreed and who had approved it, and there was a patronising reference to, we've also identified a number of learning experiences regarding policies, procedures, systems, and Birmingham Council relationships with external partners regarding such matters. I then had a meeting with Sheila Espin and Nicola Shipley and the Communities Manager from Mosey District on the 4th of April, at which I was advised that circumstances regarding the events leading up to mutual exchange were still under investigation. But since that time, over 6 months ago, and despite repeated requests, no explanation has been given as to why the mutual exchange was authorised, why Mosey District were not told about the problems that the council had with Lee Sinclair, despite the fact that there was nothing confidential about them, and who the officers were who had discussed the mutual exchange and had agreed that it should go ahead without the true facts being made known to the Housing Association. Nobody has held their hands up and taken responsibility for what's happened, least of all the person who was responsible for the housing department. Mosey District have tried to assist Nicola Shipley by taking the matter back to court, and earlier this year the court ruled that Mr Sinclair should give up possession of his property in Jakeman Road, but that the possession order will not be enforced if the defendant complies with 7 conditions and 4 undertakings. The order is for 2.5 years, but since that time, Nicola Shipley has reported continual breaches of the order. And 8 months further on, she's still suffering, as are other local residents who are terrified of the consequences if they have to appear in court to support their witness statements. Mr Speaker, I come to the conclusion. I said at the beginning of this debate there are many good people working in Birmingham's housing department. There are also, I regret to say, people who are involved in this case who put their own self-interest and desire for a quiet life before their duties as housing officers and public servants. These people ought to suffer the full consequences of their actions. However, the fact that no information has been forthcoming about the Council's internal inquiries leads me to the conclusion that senior officers, right up to the Director for Housing, seem to be more concerned with covering their own backs rather than seeking the truth of this disgraceful episode and trying to put right the grievous wrong which was inflicted on this young lady. Elaine Elkington should have involved herself in this case by taking disciplinary action against those members of her staff who conspired to keep the truth quiet about Lee Sinclair and authorised the transfer exchange. She should have looked at innovative ways of helping Nicola Shipley, who's trapped in her own house because she cannot move. She could, for example, have offered the council to buy her property and add it to the council's list of housing resources. She could have authorised compensation to Mosey District Housing Association for the costs they've incurred in management time and court costs, but she has instead presided over a cover-up with nobody being held responsible and nobody being accountable because Lee Sinclair is no longer a council tenant. She should take responsibility for what has gone on in her department, and Mr Speaker, I believe she should go.
To reply to the debate, I call the Minister.